duty and or criteria for the verification of signatures. There are several other grounds that I will not read. In Civil Appeal number 293 of 2021, the Attorney General versus David Lee and others, in his memorandum of appeal, the Attorney General raised 31 grounds, and I'll pick a few of them, that the learned judges of the High Court erred in law by finding that the basic structure doctrine applies to Kenya, for holding that the basic structure of the Constitution can only be amended through the exercise of the sovereign power of the people in the exercise of their primary constituent power, and not as contemplated under Articles 255, 256, and 257 of the Constitution, by finding that certain provisions of the Constitution are insulated from amendments and thereby classifying them as eternity clauses, by admitting and vividly relying on submissions of purported amicus curiae that were partisan, by holding that the amendment bill was not in tandem with an amendment of the Constitution by popular initiative as provided under Article 257 of the Constitution, in misinterpreting the role of the President and the Executive in the process in the process leading to the amendment bill, in holding that the power to amend the Constitution through the popular initiative route is reserved for private citizens, by misinterpreting Article 257 with regard to the persons or entities that can promote amendments to the Constitution, and holding that the BBI National Secretariat could not promote a constitutional amendment, by holding that the BBI process was not in compliance with Articles 10 and 33 of the Constitution, and in failing to appreciate that the amendment bill was subjected to all processes and motions contemplated under Article 257 of the Constitution. Civil Appeal number E294 of 2021, Uhuru Muigai Kenyatta versus David Lee and 82 others. The appellant, through Mr. Waweru Gatonyi and Company, raised 17 grounds of appeal, and I'll summarize some of them. He contended that the learned judges erred in law and violated or acted contrary to the rules of natural justice by making a decision adversely affecting the appellant and without hearing him, contrary to the provisions of Articles 27, 50, and 159 of the Constitution, by failing to find that the respondents, as petitioners in petition number E426 of 2020, having joined the appellant as a party to the petition, elected not to serve the said petition on the appellant, and further elected to abandon the suit or further proceedings against the appellant in the, I'll take that again. Having joined the appellant as a party to the petition, he elected not to serve the said petition on the appellant, and further elected to abandon the suit altogether. In finding that there was a preliminary issue to be determined as to whether the appellant could be sued in his personal capacity and not as the President of the Republic of Kenya, in spite of the fact that the appellant was not a party to the proceedings before the court at the election of the petitioners. In finding that the appellant neither entered appearance in the proceedings nor filed any grounds of objection or a replying affidavit, and in proceeding to hear and determine issues that had already been heard and determined by a competent court of concurrent jurisdiction in the matter of Third Way Alliance Kenya and another versus the head of the public service, Joseph Kinyua and 2 others, and Martin Kimani and 15 others in 2020 EKLR. The appellant further stated that the learned judges erred in making a declaration that he had contravened Chapter 6 of the Constitution by initiating and promoting constitutional amendment process under Article 257 by failing to, and by failing to appreciate the scope and extent of the constitutional doctrine of presidential immunity granted by Article 143 in light of the constitutional mandate and the obligations imposed on the office of the President by Articles 131 and 132 of the Constitution, in finding the appellant acting as the President of the Republic of Kenya can be sued in a civil court in his personal capacity during his tenure of office, and by failing to adopt a holistic and contextual interpretation of the constitutional provisions regarding the powers and exercise of presidential authority to meet our constitutional aspirations and values. There are also three cross appeals that were filed by the 15th respondent, that is Kenya National Union of Nurses, the 72nd respondent, that is 254 Hope, and the 76th respondent, Mr. Omurara Omoke. The 15th respondent's cross appeal was premised on 6 grounds, and I'll briefly state them. A, that the learned judges of the High Court erred in 1, ignoring, misapprehending, and misconstruing the doctrine of stare decisis and the stability of the common law. B, in failing to appreciate the petitioner's claim before the trial court on abuse of power, lack of public participation, and breach of legitimate expectation by the BBI task forces against the 15th respondent. C, in finding that the 15th respondent's petition for an independent health service commission was unmerited and could not be admitted for inclusion as a constitutional amendment. D, in failing to take judicial notice of the state of health care in the Republic of Kenya. E, in failing to consider and understand the claim before them and the written and oral arguments in support. F, in dismissing the claim before them after holding a contra review that the respondents in the petition had produced no evidence that there were contrary views to its proposals on constitutional amendments that were adopted in the first BBI report, and which recommendations were illegally left out of the Constitution Amendment Bill. The 72nd respondent, that is 254 Hope, raised 4 grounds of appeal, stating that the learned judges erred in failing to find that where the national executive or any of its task forces makes proposals, including legislative proposals and proposals to amend the Constitution, such proposals are subject to Article 47 of the Constitution. 2, in failing to find that the proposals to amend the Constitution for the failure to meet the threshold of rationality, justifiable reasons for the amendments connected to the stated purpose of the amendments and unreasonableness. 3, in ignoring that when the national executive or any government agency proposes to amend the Constitution, it is subject to a culture of justification through cogent and constitutionally sanctioned reasons in accordance with the Fair Administrative Actions Act. And lastly, in failing to find that there was a violation or at least a threatened violation of the prudent use of public resources, including human resources and funds, when the national executive initiated the amendments of the Constitution. The 76th respondent challenged parts of the decision of the High Court by raising the following grounds of appeal. A, that the learned judges erred in law by declining the prayer for an order that President Uhuru Muigai Kenyatta makes good public funds used in the unconstitutional constitutional change process promoted by him through the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, despite making the findings that he had no constitutional mandate to initiate constitutional amendment through popular initiative and that he violated the provisions of Chapter 6 of the Constitution. B, by declining to order the Auditor General to establish the amount of public funds utilized in the promotion of the Constitution of Kenya Amendment Bill 2020. C, by declining to order President Uhuru Kenyatta, Honorable Raila Odinga, and the BBI Steering Committee to publish or cause to be published details of the budget and public funds allocated and utilized in promoting the impugned bill. D, by omitting to make a finding that the illegal authorization or use of public funds to initiate and promote the impugned bill by the President in the midst of the COVID-19 pandemic contravened Articles 10 and 201 of the Constitution. E, by omitting to take judicial notice of the huge amount of public funds, including a 4 billion car grant to MCAs who had assisted the President in promoting the Constitution Amendment through the Building Bridges Initiative, and that the surge in the incidence of COVID-19 associated with political rallies led by President Uhuru Muigai Kenyatta and the Honorable Raila Odinga to popularize the impugned bill has had an adverse effect on the people's right to the highest attainable standards of health, and that in view of the said issues, the prioritization of the constitutional amendments through the impugned bill was in violation of the state's obligations under Article 43 of the Constitution. F, by omitting to declare sections 32, 33, 37B, 39, 41, and 44 of the impugned bill unconstitutional. G, by declining to find and hold that the Parliament had no legal or constitutional capacity to debate and or approve the impugned bill in Parliament in accordance with the advice of the Chief Justice, retired David Maraga. Thank you. I'll stop at that, and Justice Tuyot shall now begin to read a part of his judgment. Come back later.
Thank you, Mr. President. Good morning. I choose to read just two portions of my decision. I'll start with the question of the basic structure and its application to Kenya. The basic structure doctrine prescribes that notwithstanding the absence of explicit limitations on the constitutional amendment power, there are implied constitutional limitations which guard against amendments that change the basic structure